Article 168 Evidence Canon 2515 Evidence is any manifest valid form to a minimum standard of proof that can be produced during any formal argument which is deemed relevant and may support or refute a fact that has been stated as part of the proceedings. Canon 2516 The valid form of evidence is evidence that conforms in its appearance, source, handling and presentation to the rules of admissibility and is in accordance with these canons. Canon 2517 Standard of proof of evidence is the level of validity and claim associated with evidence that supports and satisfies any associated burden of proof in bringing forth an argument. There are three forms of standard of proof associated with evidence. Evidence beyond a reasonable doubt is the highest standard of proof through evidence when the evidence presented leaves no reasonable doubt in the mind of a reasonable person that the facts supported must be true. And, 2. Clear and convincing evidence is the second highest standard of proof through evidence when the evidence presented leaves little or no reasonable doubt in the mind of a reasonable person that the facts at issue are supported and are in all probability true. And, 3. Excessive and reasonable weight. Preponderance of evidence is the minimum standard of proof through evidence when the evidence presented leaves little or no reasonable doubt in the mind of a reasonable person that the facts presented by one party are more convincing than the material presented by the other party and are in all probability true. Canon 2518 Relevant evidence means evidence admissible by law having any tendency to make the existence of any fact that is of consequence to formal argument more probable or less probable than it would be without the evidence. Canon 2519 In all criminal matters, the standard of proof through evidence must always be beyond reasonable doubt. However, in matters of civil law, the standard of proof may be distinguished between the superior standard of clear and convincing evidence versus the lesser standard of excessive and reasonable weight, preponderance of evidence. Canon 2520 Only three valid classes of evidence exist: physical, testimonial and inferential. Physical evidence is any physical object which may be considered relevant to an argument in that it provides physical support or rebuttal to a statement of fact. And, 2. Testimonial evidence is any sworn testimony by a witness having been given either in an open court, video recording or written statement. And, 3. Inferential, or circumstantial, evidence is any combination of admissible physical and or testimonial evidence which when taken as a whole through the use of logic, reason and inference implies the existence of further evidence which is unable to be physically submitted at the time of proceedings. Article 169 Physical Canon 2521 Physical evidence, also defined as real evidence, is any form or parts of a physical object intended to support or rebut a fact associated with an argument. Canon 2522 There are six broad categories of physical evidence, being object, material, chemical, biological, documentary and digital. Namely, object, being complete or self-contained objects, whether instruments, firearm, powered, non-powered, clothes etc. And, 2. Material, being parts of any material such as fiber, metal, stone etc. And, 3. Chemical, being part of any chemical reaction, residue, gunpowder, fingerprint reaction etc. And, 4. Biological, being any biological culture, sample, body part or whole. And, v. Documentary, being any printed documents. And, vi. Digital, being any digital files, audio, video, transactions, recordings. Canon 2523 The validity and therefore admissibility of physical evidence relevant to an argument is dependent upon three major qualities, being provenance, method of collection and integrity, namely, provenance signifying the ownership history of the object and its chain of custody, and, 2. Method of collection signifying how the object, evidence came into possession of the party now seeking its inclusion as evidence in the argument, and, 3. Integrity of the object, evidence excluding any possibility of alteration, tampering once collected. contamination or the exclusion of significant degradation beyond recognition since it was collected and registered. Canon 2524. The provenance of evidence signifying the ownership history of the object and its chain of custody is an important quality affecting the validity and therefore admissibility of physical evidence. As a result, there are several essential criteria that must be met in order for physical evidence to be accepted and admitted as valid evidence, namely, that the evidence has not been fraudulently manufactured, positioned, manipulated or altered in any way, and 2. That the evidence has not been obtained through fraudulent means. Canon 2525. The method of collection is an essential quality affecting the validity and therefore admissibility of physical evidence. As a result, there are several essential criteria that must be met in order for physical evidence to be accepted and admitted as valid evidence, namely, that the date of obtaining and recording the evidence, or the act, event in question does not exceed the statutory limit of charges and/or suits being brought for such a civil or criminal offense, and 2. That the collection and/or submission of evidence has been properly recorded in a record of evidence and witnessed by a clerk of a court independently of formal investigators, and 3. That the evidence has been collected using proper forensic methods and has been properly sealed and stored securely. Canon 2526. The integrity of the object, evidence is the third essential quality affecting the validity and therefore admissibility of physical evidence. As a result, there are several essential criteria concerning integrity of the storage and protection of evidence, namely, that all reasonable efforts have been made to ensure the evidence has not been accessed or handled other than through the formal proceedings to which it relates, and 2. That its authenticity may be examined by a formal expert called by either the prosecutor or defense of a formal proceedings, and 3. That it may be represented to formal proceedings on request, and 4. The forensic procedures by which evidence is collected must be able to prove that in its obtaining and in its processing it has not been contaminated by external sources that may potentially account for its existence, and all evidence obtained forensically must be recorded properly and able to be subject to scientific, expert testimony and cross-examination. Canon 2527. Where the accused in a suit has an active criminal record, physical evidence from previous criminal convictions, including the details and circumstances of the previous convictions, are automatically admissible. Canon 2528. Where the same two parties have previously been engaged in a civil suit, trial or hearing, the physical evidence from the previous dispute is automatically admissible. Article 170. Testimonial. Canon 2529. Testimonial evidence is a form of evidence obtained from a witness who makes a solemn statement or declaration of fact under oath or affirmation. Canon 2530. The validity and therefore admissibility of testimonial evidence relevant to an argument is dependent upon four major qualities, being competency, integrity, authenticity, objectivity, namely, competency is that the witness is capable of comprehending questions and capable of answering truthfully without influence, and 2. Integrity is the context that the witness has not been offered any financial benefit or that reward has been offered to a witness for his testimony, nor has the witness been threatened or coerced, and 3. Authenticity is that the words of the witness are his own and that he has not been coached in any way by any third party in what to say or not to say, and 4. Objectivity that the answers are first-hand knowledge of fact and not hearsay. Canon 2531. Unless the witness is testifying as an expert witness, testimony in the form of opinions or inferences is generally limited to those opinions or inferences that are rationally based on the perceptions of the witness and are helpful to a clear understanding of the witness testimony. Canon 2532. No testimonial evidence may be taken in court by a court official unless they themselves have agreed and declared themselves to be operating under oath. Article 171. Inferential. Canon 2533. Inferential, or circumstantial, Evidence is any evidence inferred through the application of the tools of logic and reason based on prevailing physical and/or testimonial evidence. Canon 2534. The validity and therefore admissibility of inferential evidence relevant to an argument is dependent upon four major qualities, being induction, reduction, deduction, conclusion, namely, I. Induction is the derivation of general principles from specific instances of at least three forms of physical evidence and/or testimonial evidence, and 2. Reduction is the logical elimination of possible alternatives to the conclusion derived from induction to validate the inductive conclusion is sound, and 3. Deduction is the testing of both induction and reduction conclusions by the determination of a conclusion from existing known truths, and 4. Conclusion is a summary of all three methods of induction, reduction and deduction to validate the consistency of any postulation. Canon 2535. Unlike physical evidence and testimonial evidence, the existence of inferential evidence is mandatory in any legal argument, as the application of inference in accordance with these canons ensures the integrity and correct interpretation of the other forms of evidence. Canon 2536. The absence of any valid inferential evidence negates the validity of all other claimed evidence. Article 172. Disclosure. Canon 2537. Disclosure of evidence is the acknowledgement, notification, presentment of physical evidence in the due process of any argument or dispute. Canon 2538. Prior to the commencement of any formal proceedings, all parties are required to fully disclosure all physical evidence they plan to present in a formal index of citation properly and uniquely numbered, so that the court and any opposing parties may refer to it by number or by subject name. Canon 2539. Prior to the commencement of any formal proceedings, either party may lodge an application for discovery of evidence in which specific requests for documents reputedly in the possession of another party material to the proceedings is believed to possess or control. The party receiving such a request is then obliged to respond within a reasonable time to the request or give good cause as to why such documents cannot be produced or specific requests are unreasonable or mistaken. Canon 2540. Prior to the commencement of any formal proceedings, either party may lodge an application for interrogatory evidence in which specific requests to answer certain questions are put to the other party material to the proceedings. However, no question may be put that directly accuses the other party of an offense. The party receiving such a request is then obliged to respond within a reasonable time to the request or give good cause as to why such questions cannot be answered. By default, unanswered questions of a valid application for interrogatory evidence are always answered in the affirmative at the commencement of proceedings. Canon 2541. Prior to the commencement of any formal proceedings, either party may lodge documentary evidence providing it conforms to the form accepted by the juridic person and legal system. Canon 2542. Excluding testimonial and inferential evidence, physical evidence is generally excluded from being entered into a formal proceeding after it has commenced after pleadings, unless the knowledge of such physical evidence is divulged through testimonial evidence and it can be reasonably argued that such evidence would have been presented as part of defense or prosecution if its existence were known. Canon 2543. The withholding of relevant evidence is an offense and grounds for dismissal. Article 173. Admission. Canon 2544. Admission or admissibility is the formal acceptance by adjudication of any evidence presented as part of an argument. Canon 2545. Admissible evidence is relevant evidence that complies with the rules of relevance and integrity of existence defined by these canons. Only admissible evidence may be presented in all ecclesiastical, civil and criminal matters. Canon 2546. Alleged evidence where its relevance and probative value is substantially outweighed by the danger of unfair prejudice may be excluded from admission to the proceedings at hand. Canon 2547. Alleged evidence obtained under duress relates to any verbal, written, video evidence obtained from a witness and or suspect by law enforcement, court or other officials in circumstances where the man, woman or person was deliberately placed in a state of actual or implied pressure or fear in order to gain a response is not permitted to be admitted as evidence. Canon 2548 Alleged evidence obtained without proper warrant, cause or authority to search and seize such evidence is not permitted to be admitted as evidence. Canon 2549 In ruling upon the admissibility of evidence, the judge shall not discuss or comment upon the weight of the same or its bearing in the matter, but shall simply decide whether or not it is admissible, nor shall they, at any stage of the proceeding previous to the return of the verdict, make any remark to convey to the jury that will influence their opinion of the matter. Canon 2550 In ruling upon the admissibility of evidence to be presented to a jury, a judge or magistrate shall not apply any limitation or weight to restriction based on the presumed level of jurisprudence and professional legal knowledge of the jury. Instead, the admissibility of evidence before a jury shall be the same as if it were being presented for admission before a panel of judges.